Jan Logie.
Thank you, Mr. Speaker. It's with a real sense of frustration that I rise on behalf of the Green Party to oppose this piece of legislation aimed at improving our child protection and youth justice service. The Greens and I are passionate about the care of our children and creating a society that strengthens all of our families so that the children in our care can grow and thrive. And it's gutting, actually, to be given a piece of legislation that is supposed to achieve that end, that so takes us further away from that goal. That said, I want to be clear that this piece of legislation is not a black and white issue for us. We support, albeit with qualifications, 3 provisions in this bill and would vote for legislation with just these changes. However, we deeply, deeply oppose the changes to enable wholesale delegation of core child, youth and family powers. And we also oppose the token involvement of Māori in the development of this legislation when it is so central to their well-being and future. So we find ourselves unable to support it. And to be clear, in our opposition, we are no way arguing for the status quo, and our opposition must not be interpreted in that way. We are arguing for a strong, functioning society that cares for our children and a care and protection system and youth justice system that protects our children and the aspirations of Māori and all of our communities. We support the raising of age for care and protection to 18. I think it's a brilliant idea. It's been asked for a long time. Though we do agree with submitters that it doesn't actually make sense to raise the care and protection age and not the youth justice age. Most of these young people in youth justice are in care and protection. They're the same young people. So to say that you're a child till you're 18 in terms of care and protection, but you're an adult at this age if it's youth justice when it's the same kid, how are they half adult, half child? It doesn't make sense. And as the Office for the Commissioner for Children said, it will create an administratively burdensome and inefficient system, not to mention continuing to breach our commitments to the United Nations Convention on the Rights of Children. And it's frankly embarrassing that New Zealand is one of the last countries in the world still treating children as adults in our justice system. The Green Party, though, also supports the establishment of the new youth advocacy service in this legislation that will support young people to express their views on matters that are important to them, and for the CE of MSD to listen to their views on the operation and effectiveness of services provided under the Act. Great. However, again, it could go further, and we agreed with the submitters that international best practice would also have the role of that organisation be to connect children in care, to advocate for individual children in care. And that is a core function that is missing from our system at the moment. And it is a check on the functioning of the system. And it should empower children in care, supporting them to speak up and invest in training and development to grow their leadership. So it's a shame to us that this legislation is missing the opportunity to do that. We also support embedding the views of children and young people in the new operating model, with a slight concern that we do not see children in isolation from families, and that actually it needs to be supporting that family as well. But we do support the new section 11(2)(c), which requires suitable supports to be provided for children who may have difficulties expressing their view. And that has been a glaring omission in our child protection and youth justice systems up to this point, and we're very pleased with that provision. However, we again support the views and the concerns raised by the Office for the Commissioner for Children that it isn't specific enough that we've actually, within the existing legislation, got provision that says that the child's views are supposed to be taken into account. But because there's not detail in the legislation, it's not happening. So we supported those submitters who were asking for more detail so that actually the intent of the legislation would have more chance of being realised. So that's our areas of support, and they are significant things that we do support. However, there are those two major things driving our opposition that cannot be avoided and for us ruin this entire piece of legislation. So, to speak first to the monocultural design of this process of leading to the development of this legislation. So, initially, the expert panel that started all of this process off did not have one Māori member on it. And it was only later, further on in the process, when there was a stink about that, that the minister appointed one Māori member to that panel. The panel, in terms of its wide consultation, did not consult with Te Puni Kōkiri or any iwi social service provider. This is when you recognise that 60% of children in care at the moment are Māori, and that historically child protection and uplifting of children has been an absolute tool of colonisation, that this government did not consider it necessary to consult with TPK or iwi social service providers. And they, of all the people they consulted, only 7% of them were Māori. 60% of kids in care, 7% of the people they talk to. It is a perpetuation of that monocultural design. And we're not going to get it right until we go back to the people that are affected, the people who know what works. And we can't, on that basis alone, support this legislation. And then on top of it, this bill introduces wholesale delegation of powers. And I think Jacinda Ardern articulated really clearly in her speech why we're concerned about that, because this is the power to uplift children from their homes, and that power is being taken away from social workers and police officers who are specifically trained, and we have concerns around some of the limitations of that training at times, but given to who knows who? We don't know who. And as it was said by the New Zealand Council for Christian Social Services in their submission, they felt they couldn't even comment on this provision on the bill because actually nobody knows who these powers are going to be given to. You can't even sensibly respond because it's so broad. It could be any power given to almost anyone. That is not responsible lawmaking. The Office for the Commissioner for Children was quite tactful in their criticism, noting that the legislative process seemed to have outstripped the policy process, i.e. we're passing legislation without knowing what we're doing. Social service providers Aotearoa also pointed out quite significantly, I believe, that the guidance provided by the State Service Commission clearly says a delegation outside the public service should clearly specify which services or functions are to be delegated. This bill does not. So, the Green Party will protect the independent relationship of NGOs with families and explicitly restrict coercive powers to the statutory sector. This bill does not do that. It risks fragmenting an already deeply fragmented system that will put our children further at risk. We will not support legislation that could lead to the role of uplifting children being delegated to people outside of the public service. We will not support legislation that could lead to profit-making organisations such as Serco playing an increased role in youth justice or care and protection. We know that Serco are doing this currently in the United Kingdom. They have experience, but not the kind of experience we want. We've seen what's happened by giving Serco control of our prisons. Do we really want to pass legislation that would enable, if not this minister, another minister in the future, to give them the role of our most vulnerable children? The Green Party doesn't.
Derek Ball.